I'm Annie Arbenz. I am an estate planning attorney in Washington State.
And I'm Hannah Rowland, and I'm also an estate planning attorney in Washington State, and I'm also Annie's sister.
We created Orbit Wills, which is an online estate planning website to get complete estate plans done online without having to meet with an attorney, because we know that that can be very cost prohibitive for most people.
And today we're going to be talking about the essential documents that are included in an estate plan. I always say that an estate plan is not just the documents, but they are a necessary part of every complete estate plan.
And most people don't really know what estate plan means. It means a lot of different things to different people, but for purposes of today, we want to just focus on the basics of an estate plan, the important documents that you need that we provide at Orbit Wills in order to get what we think is a basic, straightforward estate plan. So if you feel like you need to get something done in this area, you don't know what it is, we want to break down those documents for you today. So what are they?
So today we will be talking about a will, a financial power of attorney, a healthcare power of attorney, a healthcare directive, and something called a disposition authorization. So if you've ever wondered, why do I need a will, or what does a power of attorney do, then this video is for you.
Let's jump in. The most important document that's part of your estate plan is the will, and that's usually what most people know about, but I don't think that everyone understands exactly what a will does. So it helps to understand what happens to your estate after you die if you don't have a will. And in that case, what happens is state law comes in and says, this is who's going to be your executor, or the person in charge of your estate and all the details, and this is where your estate is going to go. And administratively, there's a lot of complicated stuff that happens if you don't have a will. So our advice is always to have a will that says who's in charge of the estate, who is your executor, and where your estate is going to go.
I will sometimes tell my clients, you have an estate plan. It's just whatever the state decides for you, which is not always in line with what you would want for yourself.
That's true. For example, state law says who your executor will be, and that person is usually your spouse, or if your spouse isn't around, it's your children. That's not always the best move in a family. So often our clients are choosing who they think is the most responsible, the most resourceful, and really we call them the doers of the family, the people who will get things done. And it might not be a family member, it might be a really close friend, but either way, you're saying who should be that person, and that's really important. So the executor designation is very important. Secondly, a will defines how things are going to be distributed when you die. And so here you can say, I want everything to go to my kids in equal shares, but I want it to go into a trust for them until they reach a certain age, or I want to disinherit one of my children. I actually want my entire estate to go to charity, or I want these specific things to go to this one kid and the other things to go to this other kid. And you can just be very intentional in a will and say how everything should go, and you just have more control over everything and get it in writing so that there's no confusion after you die.
One thing that a lot of people will say to me, well, I just want everything to go to my spouse, so why do I need a will? Right? And even if that is the legal end, right, that's the legal conclusion of what will happen to your assets, having a will makes the whole process a lot smoother. That being said, that doesn't always happen though. Even if you're married and you have property that was treated a certain way during your life, your kids might be entitled to that instead of your spouse. So you want to make sure that it's in writing so that what you want actually happens.
Yep, and that can result in some really awkward family conversations. So think of your will as your voice after you're gone. It gives clear directions on your assets, it saves your family stress, time, and money, and it makes sure that your wishes are legally recognized.
The next important document that we prepare is called a financial power of attorney. And a financial power of attorney is where you can actually appoint someone to handle your finances and handle all of your major decision making if you are unable to make those decisions for yourself. And similar to the will, it's easier to describe what happens without that document. And let's say you're in a situation where you can't make decisions for yourself and something needs to happen. Your mortgage needs to be paid. You need to file your taxes. There's a lawsuit against you, something like that. Then your family would need to go to court to get something called a guardianship or a conservatorship over you. And at that point, the court is in charge of deciding who's in charge of your life, basically. Right. And then your family has to pay for the guardianship proceeding, and it can really slow down the decision-making in the process.
Oh, and it's like $10,000. Like, it's not a cheap undertaking. So it's a very big deal to have to go through a guardianship. So it is incredibly important to do what you can to avoid that.
Totally. Ugh. And think about all the stress it can cause your family. And I think of a financial power of attorney as like holding on to some of your own autonomy in a situation where you don't have a lot of that, right? You've appointed who you want to make decisions on your behalf instead of the court doing it for you or your family fighting over it. So I think a financial power of attorney is really important because it provides clear direction on who you want to be in charge of your assets and basically all of your other business affairs if you can't make those decisions for yourself.
I think it's really important to pick the right person because with a power of attorney, the financial power of attorney, all you're doing is giving authority to someone else. You're not telling them the decisions that they should make. You're just saying,
that's exactly.
I trust you, so you make decisions for me that are consistent with what I would make for myself. If you choose one person and you don't love what they're doing with their decisions, then you can change it to get someone that you think makes better decisions.
It's a lot of authority you're giving over, which is why it's even more important that you make that decision for yourself instead of the court making it for you.
And keep an eye on it over time.
That's right. This document and all these documents we're talking about today can be changed. And so that's something I always tell clients is, hey, let's just get decisions for you today, and then you can change them if you need to. And in fact, you should every few years reevaluate things and make sure it's still the person that you want. The other document that is similar to the financial power of attorney that we prepare is called a healthcare power of attorney. And as you might imagine, this document is specifically for healthcare decisions. And this one's important, obviously, because healthcare decisions are very important, but it's separate from the financial power of attorney because we may want a different person in charge of your healthcare decisions. Say you have someone that you really trust for, again, finances or your asset management, but you may not trust them to make healthcare decisions for you. We can separate that.
We have a lot of clients who are like, one kid's great with finances, but that person would pull the plug on me as soon as they had the opportunity. So we don't want that person making healthcare decisions, or maybe you do, but you need to be aware of that distinction, right?
And similar to the financial power of attorney, if we don't have someone appointed, we again have to go through the guardianship proceeding, which can be really, really problematic with healthcare decisions because a lot of those are made on an emergent basis, right? We need decisions for someone today in order to keep their healthcare intact, right? And so the healthcare power of attorney is incredibly important. And again, selecting the right person is incredibly important because it's not just whether the plug is pulled or not, right? It's who can visit you, who's driving you to appointments, what kind of medication will be provided to you. So again, selecting the right person for this role is really important. I always say powers of attorney are really, really important for unmarried folks too, because say you are trying to visit your long-term partner in the hospital will probably not let you in to see that person if you're not legally authorized to do so, which is what a healthcare power of attorney can do. So a healthcare power of attorney is especially important because a lot of times medical decisions need to be made quickly, and a court process can really slow that decision-making process down.
The next important document is a bit heavy, but it's also very important. It's called the Healthcare Directive. And this is what people call the pull the plug document. And it is literally where you decide whether you do or do not want to have life-sustaining treatment in the form of artificially provided food and water if you're in a permanent unconscious condition. Now, that's a lot of lawyers speak to say, if you don't have brain function and you're just existing on medical devices, you can say before that happens, so you have to do it while you're alive and well, you can say that you don't want those types of life-sustaining treatments and instead you'd like to be let go. And that's the pull the plug aspect of this document. This is not a DNR, as a do not resuscitate me. This is as something very dramatic has happened, I don't have brain function and I will not get it back, so you can let me go. This is really important for your family because if you don't make that decision in writing, then your healthcare agent under your power of attorney has to decide what to do with you at that point. And it is not fun to decide to let your family member die. I've used one of these documents in real life, and it is so wonderful to have it in writing that my loved one said, "Don't let me live like this." And then I didn't feel as guilty making that decision for him because it was his decision. So I was just implementing his decision. So we call it a guilt mitigation technique, right? To say, hey kids, don't worry, if I'm in this position, don't let me live like this. This is a rough one. It's a rough one to think about.
And even if you've had that discussion with your kids or your family members, there's something about having it in writing and making it legally enforceable that really does take that burden off of the healthcare agent and honestly kind of helps family relations at that point.
Yeah, I would say so. And it's a difficult decision, but I can guarantee that it is harder for your kids to make that decision than it is for you to make that decision in advance. So this is a really important one. We believe everyone should have one in their medical file.
Next up, and our final document that we're going to discuss today is called a Disposition Authorization, or a Disposition of Remains. And this one is multiple choice. So you can choose if you would like your body to be cremated, buried, or in certain states, including Washington, composted. And this one's really important, believe it or not, because without this document, your family all has to agree on what's going to happen to you after you've died. And it may not sound like a big decision now, but at the time, it actually can cause a lot of family tension and a lot of problems. And so again, this is all about providing clarity about what you want. Even if you're not completely sure, a decision now is better than them making the decision later.
Mm-hmm. This has come up where a client has an estranged child or a kid who's not really involved in their life anymore. A memorial home will track that kid down. They have to legally track that kid down to make sure they agree. And guess what? They'll never agree because that's not the relationship they had.
Signing a disposition authorization really prevents conflict at a time that's really highly emotional for your family. And so just providing clarity on what you would have wanted is really a gift to your family.
So to recap, a complete estate plan includes the following documents: a will, a financial power of attorney,
a healthcare power of attorney,
a healthcare directive,
and a disposition authorization. Each of these documents protects your voice, your family, and your peace of mind. You are providing clarity, so you're taking the guesswork out of things after you've died and making sure that there's minimal conflict at that time for your family.
And you can get all of these documents done in 3 business days at the fraction of the cost of a traditional estate plan by going to orbitwills.com.
Simple wills
for smart people.